Arnaldo, if you could just briefly explain just a little bit more, question coming in from one of our attendees, if you could explain just a little bit more on the French blocking statute, please.
Sure. So as I was mentioning, the French blocking statute was enacted to basically prevent French companies from disclosing commercial information in foreign litigation absent a court order. So what a company should actually do before disclosing information in the context of a foreign litigation, which should be interpreted broadly and should therefore include investigations by, for example, the DOJ of the SEC, should actually file a request with the court, with the French court, that could grant or deny the authorization to produce the document in the foreign litigation. As I was saying, unfortunately, the statute is not used in common practice, meaning that very rarely companies actually make such requests before French courts. And this is because they're always afraid that delaying the response to a request by U.S. authorities such as the DOJ or the SEC could be interpreted as a willingness not to cooperate with them. And so in order to avoid, for example, a higher fine because the DOJ or the SEC say that the company was not cooperating, they prefer to run the risk of receiving a fine under the blocking statute. As I was saying, the fines are not very high, which is why Raphaël Gauvin recommended to increase the sanctions, and the French Anti-Corruption Agency is, among other things, supposed to verify compliance with the blocking statute. So I'm seriously expecting that the regulation will be will be enhanced in line with the recommendations included in the Gauvin report in order to limit the investigations of especially U.S. authorities against French companies.